the umpire who conducted an election which is being disputed, to show that they conducted an election that conforms with the requirements of the law. Because the usual question for you to qualify to challenge an election is substantial non-compliance. Now, substantial non-compliance is a procedural thing. Now, so if INEC says that this is a procedure for the conduct of an election, for instance, in the last presidential election, INEC said electronic transmission of results was mandatory. Yet, in the process of the conduct of the election, while results were being collated, INEC now came up with some kind of excuse that their network suffered a technical glitch.
Good day, good day, good day. Yes, that's the way they say it in Australia. Good day. You know, if you look at the time zone, some of you are just waking up. Some of us, it's midday. Some are going to sleep. To my friends in Bangalore, they're almost 12 hours ahead. So that's why I say good day. So instead of saying good morning, good afternoon, good evening. Yes, it's another Friday, State of the Nation. Yes, we've been running this series on the Atlantic Discuss channel, State of the Nation, on electoral reforms in Nigeria. It is important. It is vital. Nigeria is the largest concentration of Black people. You know, the elections in the past, we know were free, but not fair. Now people say they are not free, they're not fair. So what can we do, you know? So these are third part. We spoke to Randy Peters, you know, an activist. He said so much. We spoke to a lawyer last week, you know, was the second person, Mr. Gucci, a national lawyer. He made it clear. Transparency, you know. Now we're talking to Honourable Adum Ter, yes, a lawyer himself, a politician, former Attorney General in Benue State, and so on and so forth. Mr. Ter, welcome to, let me say Honourable Ter, welcome to Atlantic Discuss channel.
Thank you, my brother Ade Balogun.
Yes, Mr. Ter.
I'm glad to be on your set this morning. Okay. And I'd like to send out compliments and greetings to all our listeners and viewers across the world. Thank you very much.
You're most welcome. Yeah, Mr. Ter has been Commissioner for Attorney General and Commissioner for Justice.
Yeah, I was the Attorney General and Commissioner for Justice in Benue State. I had also served as the Commissioner for Common Industries. Okay. And then director, rather, of the Benue Attorney at Law. And I'm also a politically exposed person, having worked previously as a political actor at the level of contesting elections, not winning, losing anyway, but also serving as a member of the Presidential Campaign Council of the PDP. Indeed, at the last election in 2023, I was the head of the Mandate Protection Unit of the PDP, and also head of the Situation Room.
Interesting. Wow. So, but now
so I believe my experience. Yeah, now I'm a member of the African Democratic Congress. Okay, fantastic. Because the fact that the PDP is no longer living up to its name as the opposition party, which is ready to form the next government. So the African Democratic Congress presents itself as a better alternative. And a number of us who are completely overwhelmed with the shenanigans going on in the PDP opted to resign from the PDP and register with the African Democratic Congress. Indeed, I am just stepping out of a meeting of the African Democratic Congress, the Benue State Steering Committee meeting, which is ongoing. to conduct this interview with you. So I'm very, very much a member of ADC.
Okay, fantastic. I appreciate the way you highlighted it. So you are eminently qualified for a discussion on electoral reforms, because I'm sure the ADC, because I listened to your national chairman some days back, and but let's put it this way: what specific reforms are necessary, to improve credibility in the Nigerian electoral system? From a perspective as a lawyer, a politician, and what have you, what are the specifics that you want, or your party, whether at your state level, national level, what you want to see specifically be done electoral reform-wise?
Well, elections generally is a process. It's not a one-day event. So the reform that I would want to see in the conduct of election in Nigeria will start from the reform of the electoral management body, which is the Independent National Electoral Commission. And in that regard, the specific items of reform as it relates to INEC, the independence, or it should be practical independence. Paper independence in the sense that you say on paper INEC is independent, but in practice, INEC is tied to the apron string of the incumbent political party. Thus, such an institution cannot be said to be independent to conduct an impartial election. So my first shot will be, how do you appoint the national chairman of INEC and the national commissioners of INEC and the resident electoral commissioners? As it is presently, the President of the Federal Republic of Nigeria is solely vested with the powers to appoint the INEC chairman, national commissioners, and the resident electoral commissioners. Can that kind of institution, as composed by the incumbent president's appointees, be said to be independent in practice? The answer is certainly in the negative. So the first reform, remove the powers of appointment of INEC principal officers from the exclusive control of the president. Now, the question will be, how do you achieve that? Progressively, there have been some tinkering with the Nigerian constitution to the point where today you have a situation where the president, before appointing the national chairman of INEC, for instance, holds a scheduled consultation with the National Council of State. And the National Council of State is comprised of all former presidents, all former chief justices of Nigeria, all former Senate presidents, and all former speakers of the House of Representatives, and the 36 state incumbent governors and the Attorney General of the Federation. That kind of body, the chairman is still the president, the incumbent president of the Federal Republic of Nigeria. That kind of body, populated by people who are incumbent, like the governor and the president, who are in the majority number, because remind you have 36 state governors, and these 36 state governors, as it is today, most of the governors have been lured or induced or have been coerced into joining the APC. And so they're practically going there to go and adopt the position of the president. That kind of body cannot give the president the kind of advice, to appoint an impartial umpire, head of the umpire for the commission. So my advocacy is that let the political parties that are registered in Nigeria, now, provided such political parties have participated in election and at least have a member representing them at the level of the National Assembly, which is the only qualification that makes a party remain on the ballot. Otherwise, you're registered. Let these parties be the ones to nominate 3 names, for appointment to the president. Indeed, the incumbent political party must also be limited to 1 nomination, and the president must be under obligation not to appoint the person nominated from his own political party, to be the chairman of the state, the national. They might thought the president. The second type of reform that I would want to see in terms of our electoral management system is the process leading to election and the process on election day and the management, collation, and announcement of results. Now, as it is today, one of the critical challenges of election in Nigeria today, it is not the manipulations at the polling units. The manipulations of the polling unit have been fairly reduced to its barest minimum. I can say almost 90% of the shenanigans that used to go on, like ballot box snatching, result falsification, and disruption of voting at the polling unit, these things have been fairly, reduced to a barest minimum. The problem, however, is to be able to make a system such a way that we can ensure the transparency of the process. And so how do you ensure the transparency of the process? First and foremost, result collation must be done in a way and manner that is technology driven. And that's where the electronic transmission of results is a very critical innovation that must be improved and adopted without any condition so that you can minimize
Mr. Ta, I can't see you. Can you put on your camera, please?
So that you will minimize the analog system of collation of results. Now, analog collation of results should be a backup to the electronically transmitted results. Look, even in Ghana next door here, electronic transmission of results is a given. Technology has improved in such a way that Nigeria cannot be coming behind the rest of the world in terms of its election management, that we have to wait about 3-4 days after the conduct of a presidential election before results are announced. Even India, a 1 billion plus democracy, results are almost announced instantaneously. So if we want to improve our electoral management system, the new amendments to the Electoral Act should mandate INEC to transmit results electronically, seamlessly, and instantaneously from the polling units. In that way, you can eliminate the rigging, the tampering, and the mismanagement of electoral results at the collation centers. So if it's for an election for the councillor, for instance, once the results are transmitted to the polling unit to the next collation level, which is the local government the ward collation center, the results are announced there immediately. And so if it's for a local government constituency, once the results get to the electronically, they are announced. And once the electronic transmission of results has been carried out, any paper results that are produced are only to back up. If there's an inconsistency between the electronically transmitted results and the paper results should differ in favor of the electronically transmitted results, which are viewed globally from every source. Then for state elections, for national elections. So you can conduct presidential elections in Nigeria, and by 5 p.m., the results are all over the place. And if a new president, is announced technically, once the results are there, it will be easy for even someone who has lost, to fairly call the winner of the election, congratulate him, before the next day. In that way, we can reduce the post-election litigations, which is one of the biggest things that has corrupted our judiciary. Because when the stakes are so high, and you allow the court to determine who has won an election, corruption will definitely set in. And that's why most times it is very, very difficult to get, judicial determination of electoral matters in a way and manner that accords with everybody's reasoning or the reasonable man on the street understanding of what is defeat and what is victory. Now, when you do that, you would have strengthened the electoral management system. Then, of course, even if we have to go to the judiciary, the Electoral Act must be also strengthened in a way and manner that the conduct of electoral litigation is done in a way that accords with the understanding of everybody. I know we run the adversarial system of the inquisitorial system of adversarial system of criminal justice. And so the burden of proof is on he who alleges. But in electoral matters, it is not the loser of the election that is on trial. It is the winner and the umpire who conducted the election that are on trial. So the system must be such that the burden should be on INEC, the umpire who conducted an election which is being disputed, to show that they conducted an election that conforms with the requirements of the law. Because the usual question for you to qualify to challenge an election is substantial non-compliance. Now, substantial non-compliance is a procedural thing. Now, so if INEC says that this is a procedure for the conduct of an election, for instance, in the last presidential election, INEC said electronic transmission of results was mandatory. Yet, in the process of the conduct of the election, while results were being collated, INEC now came up with some kind of excuse that their network suffered a technical glitch. Then mutilated copies of Form EC8A, which is the primary document for the collation for the imputing of electoral figures. You see them mutilated, cancelled, destroyed, left, right, and center. And it took INEC 5 days to collate the presidential election and then announce the result in midnight when everyone was sleeping. That is not the procedure for collation and announcement of result. So the question is, should the law be focused on the loser of the election, or the law's sanction should be focused on the electoral management body which failed to conduct the election in accordance with the spelled out guidelines, regulations, and the Electoral Act? So in Kenya, for instance, in 2016, I think 2016, I guess, or 2018, the Supreme Court of Kenya took only 1 month to hear the complaint of the presidential candidate who lost the presidential election to the former president, that's President Kenyatta. And the Supreme Court heard that the electoral management body did not conduct the election in substantial compliance with the Electoral Act. So what they were looking at was not whether or not every polling unit, evidence was called from every polling unit to come and determine the conduct of the election. What the Supreme Court of Kenya looked at was whether or not the Independent Electoral Board of Kenya followed the law and its guidance and regulations in the conduct of the election. So they heard all of that in 1 month. And in 1 month, they nullified the presidential election in order for, a rerun of the presidential election. In Nigeria, in the current situation that we are, and the jurisprudence of, election litigation in Nigeria, no Supreme Court will ever nullify a presidential election, because the requirement is for an individual who is challenging the conduct of the election to bring evidence in over units, and to do all of that within 6 months. It's impossible. So if you reform the procedure for election litigation in Nigeria and shift the burden of proof from the petitioner to the electoral management body, I'm not saying the winner of the election, but to the electoral management body, because it is the electoral management body that is on trial. So if it can be proven, and these improvements have been made, like in the 2020, in the last electoral act that was used to conduct the 2023 general election, the amendment was there, stated in black and white, that where you have documentary evidence that are, endorsed by INEC as certified true copies of their document, and you tender it before the tribunal, there will be no need for you to call, witnesses, individual witnesses to come and testify on oath on the admissibility of this electoral, document, Edo state off-cycle election. Whereas the tribunal followed all of this and admitted all of these documents. The only simple technical reason why judgment did not go in favor of the petitioner was that the petitioner did not call, witnesses to come and testify to those documents. If documents are admitted, the principle is the evidence is on the face of the document. And if the evidence on the face of the document, the maxim is reps ipsa loquitur. The document speaks for itself. So you don't even need any oral evidence from any witness, to come and testify for you to believe. These are public documents that have been certified by the electoral management body as their own documents. So why do you need, officers of INEC who are in control of the president or the incumbent political party, to come and testify? And in any case, most of these officers, when you subpoena them to come and testify, they refuse to come because they need approval procedurally, administrative procedure. They need approval from their national chairman. The national chairman is beholden to the incumbent party and the incumbent president. So he cannot release staff of INEC to go and testify for you. So most of the times you can't find witnesses to testify to those documents. Those are technical issues. So you don't need to make it incumbent on the petitioner to be the one to call witnesses who are not under his control to come and testify. In the presidential litigation, witnesses summoned by INEC, subpoenaed by court order, refuse to come and testify. So that is the kind of reform that I want to see. First, the institutional reform relating to the appointment of the management of INEC. Two,
procedural.
The electoral process reform, which in terms of voting and collation transmission of results. Then three, post-election litigation reform, so that we can streamline the process, make it shorter in such a way that the focus of the courts will not be on this cumbersome requirement that I am contesting election in a constituency where I have 7,000 polling units, and because I am challenging the election, I'll be required to call in 7,000 witnesses to come and testify before me in court. Now, if we do that, we can reduce the time frame for litigation and also make it possible that elections are challenged and the process from the conduct of elections to transmission of election results to post-election litigation are all concluded within 90 days before the swearing in of new actors. Because when people are sworn in already, they also become a problem because they take charge of the system and the system becomes beholden to them. So in that way, you can never have, a transparent process because INEC can no longer be in a position to say they're independent of the status quo. So they all become part of the status quo. So it becomes a challenge. And that has weakened our democracy from making the kind of progress that it should make. So I say for now, those are my opening. I've taken details to explain it so that at least our viewers can understand exactly what I mean.
Yeah, that's why I didn't interject you because I was supposed to have follow-up questions. So most of my follow-up questions, you were answering them. So I was good with it. I was going to ask you, because my next question is on the judiciary. There are about 2 or 3 now. But I was going to ask you if you feel that all cases should be concluded before swearing in. And you also answered that, like in Kenya, within 1 month, cases be adjudicated and be done with. So the question now is, are you happy as a lawyer yourself? Are you happy with the role the judiciary has played in all this, in the seemingly vis-a-vis adjudication of election? I'm sure you've read Professor Dinkalu's book or heard about his electorate. There were tons and tons of examples of how the judiciary is now the last, call for that determines who wins an election. So the people's votes do not really matter. There have been scenarios where somebody came third or fourth, and the Supreme Court, just pushed the person behind to the forefront. And we've had cases that are spurious as, canceling election results, going back to the primaries, and that means that the vox populi, vox Dei does not really matter, that the judiciary now determine. So much so that even politicians or people in power will tell you after the election, when you complain and grumble, they say go to court. So are you happy with the role the judiciary has played thus far as a lawyer yourself?
No honest legal practitioner or member of the bench, even amongst the judges, off record, when you sit with them and discuss with them, all they do is bow their heads in shame and say it's unfortunate what is happening today in Nigeria. And I tell you, what has corrupted the Nigerian judiciary, with due apologies to everyone. Of course, there are exceptional judges who are still very good, but 90% of the judicial system in Nigeria today has been compromised because of the exposure to election litigation. Now, even the Supreme Court, which was a court of final, jurisdiction in this country, a court which usually intervened in a way and manner that redirected the course of the development of our law and jurisprudence, has become complicit because the Supreme Court can no longer make very authoritative pronouncement on anything in this country anymore, because judgments are given based on what is available or behind the scenes understandings that have been struck. And so, talking about electoral jurisprudence in Nigeria with certainty today, even as a lawyer, it's such that if you call me today and ask me to give you a legal advice on this, I won't be able to do that. And I won't be able to do that because you don't even know what the state of the law is, because the law is whatever the courts pronounce what pronounce it to be. But if the court have made pronouncements in the past, it becomes judicial precedent. So you can rely on that. But reliance on judicial precedent in Nigeria today is also extremely very difficult, because the courts have been turning out judgments that are totally inconsistent with what has been laid down, several years before now, which ought to have been the precedent. So I am not satisfied. And the only way you can, reduce the frustration and we're suffering today in judicial capture by the political class. Like we have one notorious gentleman, minister in the current administration, whose role is to fix elections. He comes on national, because when he was speaking in the last media chat, he said a member of one of the political parties who was a gubernatorial candidate in one of the political parties that contested the Rivers election once came to him in the course of the litigation between himself and the incumbent governor, where he realized that there was some kind of tension between the relationship between the incumbent governor and the minister. That candidate came to him and pleaded with him to help him intervene in the Supreme Court on his behalf. And the only reason why if somebody will do that and somebody will have the effrontery to come on national TV and make such a confession is because it is what is happening. The man who went to seek his intercession knows that he's a man who has undue access to the judiciary. He's a Mr. Fix-It. So that's why he can do that. And then an incumbent senator in 2022 had the effrontery to stand before colleagues in the National Assembly in the hallowed chamber of the Senate to say, colleagues have been coming to me to intercede for them who have litigations before the Court of Appeal, because senatorial election, the final court for determination of senatorial election disputes, is the Court of Appeal. He was the president of the Court of Appeal. Save their mandates before you've been to him from this nation. He went like that, and the matter died. The senator was never sanctioned. The justice in question was never questioned by anybody, neither the anti-corruption agencies or the National Judicial Council. So it's become part of the norm. That's the system. So if you want to be able to correct these things, then you must be able to go back to my earlier conversation. which is the reform of the litigation, the jurisprudence of electoral litigation in Nigeria, to ensure that the person who has the burden to prove that they have conducted an election in substantial compliance with the law and the guidelines for the conduct of the election is the umpire. And it is him who is being impeached. Because the current situation, which is adversarial, which is you put the person who has won an election together with the umpire who conducted the election fraudulently against you, and then you put the two of them together as a team. And this person is already sworn in, he's in government. The institution that conducted the election is also part of the government. They now come, the judiciary is part of the government. It will now become a trinity of three bodies against you, one individual, who is challenging that conduct. It takes the grace of God for you to be able to come out with victory in election litigation in Nigeria. You must do some extraordinary things, because that combination is an unholy alliance. So you need to reduce those on the other side, who should be on the spot that is trying the matter. The litigants who participated in the process should have minimal explanations to do before the court, because they didn't conduct the election. And the requirement of the law is that this election, for it to satisfy the taste that we qualify it as an election that can declare anybody a winner or a loser, is that it must be done in substantial compliance with the law, which is the enabling legal framework that gives the powers to INEC to conduct the election. So when INEC spells out its guidelines, procedures, and all of those things, it put everybody on the notice that this is what we're going to do. So if somebody does anything contrary to what INEC has done, has said they should be done, or INEC itself goes contrary to its own rules and regulations, INEC should be on the spot and should be punished for it. And so we now reduce the exposure of the judiciary, because once electoral malfeasance is manifest on any election or the conduct of any election, it will no longer be a question for dispute or for contest. So the judiciary's role will simply be to go and interpret the law. The law says, INEC, you said you would transmit these results electronically. Once you didn't transmit the results electronically, you are in breach of the law, except you can show us any other powers enabling you to do otherwise. In that way, the pressure even on the judiciary will be less. And the exposure of the judiciary to, corruption on account of electoral litigation will also reduce, because it takes two to tango. The judges live in Nigeria. The judges are deciding the fate of politicians. Politicians don't take no for an answer. Politicians always want to look for a way even when there is no way. Because to be a politician in Nigeria and be in public office is like being a god. So they do everything. So they are the ones who compromise the judiciary. But you also need to protect the judiciary by reducing their exposure to those politicians. And the only way I can think about it is to tweak the jurisprudence of electoral litigation to avoid the necessity or the temptation to take compromise to the judges. And the judges themselves also need to look back and reflect. The idea also that judges can determine, the mandate of an election by pronouncing somebody a winner arising from a litigation. We also need to do away with that kind of powers in our law books, in our electoral law. The question before the judge is to determine whether the election was conducted in compliance with the requirements of the law. If it's not conducted in compliance with the requirements of the law, you just nullify the election and ask the umpire to go back and conduct a fresh election. In that way, you cannot go and take somebody who came forth, like it happened in Imo State, and go and make him number one in an election where it doesn't just make sense. It's illogical. So the powers of the judiciary to make a pronouncement that anybody has won an election that power should not be invested in any judge. Indeed, it should be something that should be removed from the Electoral Act. To say the only power, once the court makes a determination that there has been a breach of the Electoral Act or the guidelines and the regulations for the conduct of an election, the only powers or only only orders the court can make will be the order for a rerun election. Thank you.
Fantastic. Thank you so much. So now from
I'm done. Yeah.
No, you're good. You're good. Let's go ahead. I have one or two more questions for you. So now we've spoken about the judiciary, INEC, and all that. So let's talk about the legislative arm of government, because everything you have said now,
Yes.
I've listened to there's this Osita Chidoka during the week. He said our technology is fantastic, that we're even more advanced technologically than Kenya and Ghana. It's just that we do not apply. That's a function of application. So now the people also, I think the guy I spoke to last week, Oguche, the lawyer, said that the Uwais report is also there for us to pick from, but that Uwais didn't do too much on technology. But now we have the technology, all we have to do is merge the two. So having said all that, the onus is on the legislature, the legislative arm of government. In this instance, is the Senate. Now, as we speak today, the APC has technically 2/3. Maybe they are one senator short of having 2/3. And your party, from all indication, have said they want to win the presidency and take over the reins of government in 2027. Now, wherein lies your optimism? Where is it emanating from? If, for example, we know that those that are major beneficiary of the status quo will not want to change it. So how do you want all these changes to happen? What's the plan? Because it's still, the politicking has taken over the entire landscape, the political stratosphere. Nobody's really talking about governance again. So how will the laws change? There's a new INEC chairman to be appointed by the president. So based on what you said ab initio, it's not going to change. The president still has to. Nobody has changed that. You understand? I'm not aware that there's a Council of State meeting that has been held, to pick a new chairman. You understand? But the president will probably nominate someone, and so it doesn't look like anything is going to change. It doesn't look like the legislative arm is going to change anything. So where's the confidence of your party coming from that there will be, you can take over the reins of government? And what are your plans to make those changes if it ever happens? Over to you, Honourable.
Democracy presupposes that there will be free and fair elections. Mm-hmm. And that's the presupposition. Now, the extant National Assembly will not do anything to unsettle the status quo. Mm-hmm. And that is why the agitation for electoral reforms are coming more from outside the Assembly. Because the extant National Assembly is dominated by members of the incumbent political party, the APC. And so it will be difficult to get them to pass an electoral act that will reflect the wishes of the people in terms of what is required to be done to be able to secure a free and fair election in Nigeria. However, do we sleep and take it as a given that nothing will happen and as such we should not try? The answer is no. Our own party is insisting on electoral reform because we know that is the right thing to do. And we are not insisting on electoral reforms in a vacuum. We are offering new perspectives, new dimensions, new take to guarantee free and fair elections. And so we are calling on the National Assembly to do the needful. We are joined by civil society organizations, we are joined by donor support organizations, and the entire country calling for these reforms. Are they likely to be, are we likely to succeed in our call? Well, I would say yes. Yes, because if the National Assembly will do the needful in response to the yearnings of the people. But that is unlikely to happen because you have a National Assembly where the leadership is controlled by the executive. And what the executive wants is the perpetuation of the status quo. Now, as a minority political party in the National Assembly, or a new party entirely, because even if you combine all the other political parties who are in the minority, to the APC, can we force the hand of the National Assembly to do what we want? The answer is no. But Can we stay aloof and refuse to participate in the democratic process, which the Constitution requires our participation every 4 years? Because the only way you can change a government under a democratic dispensation is to participate in an election. So rather than bemoan our fate and go to bed or leave it and surrender and throw up our hands in the air, that there is nothing that can be done, will not conduct a free and fair election. And so there's no need to participate. And so the incumbent party will return. We are saying no. The people's will is greater than any army put together. You know, there's somebody who said, one of the philosophers who said, an idea whose time has come, or no army can stop the will of the people. So we believe that the will of Nigerians is to have a democratic change of government in 2027. That will had previously been expressed by the people, even when the PDP was the incumbent political party in 2015. There has been inter-party transitions in Nigeria. So what we are advocating for and what we are angling for isn't something that is, an impossible task. When the opposition APC then took over power from the PDP, they had just about 6 governors. The PDP had about 22 governors initially and decamped as many governors as possible from the other political divide, and had about 27 governors, more than 200 members of the House of Reps, and more than 3/4 of the members of the National Assembly at that particular time. But a change of government at that time, based on the failure of the government to guarantee the security and the lives of the people, some of the economic challenges, the general performance of the government was reviewed by Nigerians and went to the poll. They voted, and DC is going to do isn't different from what happened in 2015. We are going to stand firm to our conviction in advocating for electoral reforms and hoping that the National Assembly will do the needful. Should the National Assembly be unable to amend the Electoral Act, able to give us an Electoral Act that the chairman is going to be fair, that is also going to be objective and transparent, and that the process of litigation will be shortened and made reformed in such a way that it is a lot more easier to prove electoral fraud actions. And we will participate, vote in our conscience. And if we secure the victory at the polling units, unit to the collation center and to the next level collation center to the next level until the results are announced. So one is going to be 2 ways. The pursuit is 2 ways. First, the reform through the legislature, putting our own members directly accountable, and one arm is to our conscience, even on the extant electoral framework, protect our results and ensure that the will of the people is not compromised by the state. That's exactly what we intend to do.
Brilliant. One last question before you go. We're pressed for time now. One last question. Are you expecting some decampment from APC, PDP into ADC? Because I know now you don't have a governor and any member of a National Assembly, really. So are you expecting like what happened in 2015 to happen?
It will definitely happen. It will definitely happen. See, it is a lot. Transition elections are very difficult to manage. Now, a number of APC governors are due for a second term. A number are doing their final term of 8 years. The president is going in for a second term of another 4 years. So many legislators on the APC platform. Now, the usual practice and the style of the APC and the man who is the president is to ensure that the status quo is not disturbed. So the conduct of primaries in the APC is going to throw up a lot of tensions. Tensions in the sense that those who are members of the APC who are angling for an open, transparent process to be able to also participate may not find that accommodation in the APC. I can assure you, no APC incumbent governor, for instance, will fail to get a ticket for a second term. Meanwhile, there are party members in the APC who are thoroughly dissatisfied with the performance of the APC. Ditto for their legislators. And these people are in the majority because the elected representatives are the minority. And these people will not find expression, or opportunity in the APC structures currently as it is. Mind you, the APC was supposed to have conducted congresses for the change of party executives as far back as March this year. That process has technically been shifting and shifting and shifting. Now they're supposed to do it in December, but I can assure you that they will not do it. And the reason they will not do it is because it will generate a whole lot of tensions. Because people will begin to feel excluded right from the conduct of those congresses at the ward, the local government, the state, and then the national listing. That it gets to a point where they're holding the fact that it is a continuity for everybody. Whereas sub-national actors have made the concession that the president can continue because it's their best candidate, it's their best foot forward. Most of the sub-national actors are not even satisfied with the status quo at the sub-national level. Some are also not satisfied with members who are representing them at the National Assembly. That whole, segment of the APC that you're going to shut out, I can assure you they will be seeking expression or finding accommodation in another place. And there can be no better option than the ADC, which is prepared as the alternative opposition should have played that role, is in disarray. The PDP, the battle for the soul of the PDP will come to an anticlimax in November in Ibadan. As we speak today, the National Secretary of the PDP, Senator Samuel Anyanwu, has been suspended from the PDP by the National Working Committee. So, because he belongs to the faction of the Minister of the FCT, who is seeking for the jugular of the PDP, simply because he has an arrangement or a brief from the incumbent APC government to ensure that he destabilizes the PDP so that they are not able to present a presidential candidate who will challenge the incumbent. That is the whole brief. And so for the PDP, it is factionalized already into about 3 blocks. Generally, the ministers' block and the block of the governors who are hoping that they'll be able to secure the platform to have an opportunity to recontest an election on the platform. And then those who want to take party leadership of the party and then continue to mismanage the party. And that is being led by Ambassador Damogun, who is standing with a few of his supporters. So there are 3 tendencies in the PDP today. And those tendencies can never agree on the way forward for the PDP. So the Ibadan Convention will be an anticlimax. And many other people from now till November and post-November, you will see a lot of resignations from the PDP. And anybody who resigns now, the only option is ADC. So we are going to harvest a lot from PDP and harvest a lot from the APC. And for the ADC, what we are saying is that it's a party of inclusivity. We are going to run a very transparent process and an objective process, right from the ward, the local government, the state, and the national level. Our primaries are going to be open for anybody to participate. The emphasis is on competence, not on origin of candidates or their location. But beyond competence, capacity and capability. So we are emphasizing 3 C's. Competence, which is you can do it better than the incumbent, but most especially the capacity and the capability to be able to run on the ADC ticket and run to victory. So I can assure you that the ADC will harvest a lot of incumbent senators, incumbent governors, incumbent House of Assembly members, and incumbent House of Rep members. The only thing the ADC will not harvest is an incumbent president, because even if he comes, we will reject him.
Benue State, your state.
Thank you, Balogun.
Yeah, but let's answer this in 1 minute because we are pressed for time. Benue State, your state, at least from my observation, looks like one of the states that the ADC is really, really strong. The chairman of the party is from there. Former Governor Susan is there. You are there. A lot of people from Benue State, I mean, we see it on news, social media. Looks like ADC is really well embedded in the Benue politics. Do you think Benue State is an ADC state by election from governorship all the way down. Do you think it's a slam dunk? 1 minute, sir.
See, Benue ADC is organized because right from day one, we took a decision that we needed to have an alternative platform to be able to organize ourselves, to first wrestle power from the incumbent maladministration that is going on by the APC administration in Benue, and then to make a shot at national change of government at the national level. So we put ourselves together, first as a steering committee of committed members selected based on political antecedent, headed by Governor Suswan. And we have 23 local governments in Benue. And out of these 23 local governments, we have 5 pillars of the steering committee of the ADC made of people who had very high levels of political exposure as either ex-senators, ex-House House of Rep members, ex-assembly members, ex-chairman of local government commissioners, and so on and so forth. So we have 5 per local government. And so out of those 5 per local government, it gives you about 120, 130 members of the steering committee of the ADC. At that time, we called it the Benue Political Consultative Forum, when we had no political platform. But we were consulting ourselves on both sides, both from the incumbent APC and those of us who were in the PDP. So it is that group that has formed the nucleus of the ADC in Benue. Funded our party based on the. I told you I just came out from the meeting of the ADC steering committee we are holding right now to just come and conduct this interview. Every month we sit together, that group of 100 persons. We discuss, we map up strategies, we determine support for the party for grassroots mobilization and registration. And so that's the model we have adopted in Benue. The people own the party. We all own the party. There is no, David Mark is not funding the party, so some is not strapped. So we contribute, whether it's 50,000 naira, it's 100,000, everything. If we levy, it's just crowdfunding. If we levy ourselves 1 million naira, we already raised 100 million. If we levy ourselves 100,000, we've already raised more than 10 million naira. So that's the way we've been funding the party. And that's the kind of model I recommend for all the states of the Federation. Don't wait for any money back to come and hijack the process. Take charge of the process of the organization of your party, fund it yourself, show your commitment, demonstrate your drive, and I can assure you that the people, the kind of reception we're getting in Benue, it is because the people have been waiting for this to come, and they've embraced the ADC as the only alternative political party that can deliver the goods for them. So that's why Benue is strong. Benue is not strong only because of the remark. Benue is not strong only because of Suswan. Benue is strong because Benue has elected to accept ADC. That is complemented by the presence of Suswan, is complemented.
All right, thank you. Well, I said 1 minute. You did more than that.
The presence of David Mark, where the ADC will sit the incumbent. Yeah. Okay. Thank you.
For governor?
Thank you.
Yes or no? Are you running for governor?
No, not in this round of elections.
Okay, all right. Thank you very much. Thank you.
I'll be running for a lesser office.
Okay.
National Assembly.
Okay, no problem. Mr. Honourable Alex Adum Ter, former Commissioner for Justice, former Commissioner for Commerce and Industry, ex-bencher. You know, it's been everything in Benue State, but governor or senator. So now it's going to the National Assembly, ADC.
With all sense of modesty, Dr. Alex Adum, because I have a Ph.D. in law.
Absolutely. I forgot to mention that, Dr. Ter.
Thank you very much.
Yeah,
thank you very much.
Thank you for coming. Thank you for your time. So to all our listeners, you've heard it. There has to be reforms. INEC has to show transparency. It's Vox Populi, Vox Dei. If the people can protect their vote, INEC has no choice. You can only read where you are popular. If in a case where you're not popular, you cannot read. Now, the recourse will be to the judiciary from what he said. The people will protect their vote. Nobody's going to wait. Well, there might be a law that will help things before that. There might not also be, like he said. But having said all that, the opposition cannot afford to give up. They have to do what has to be done. The state of the nation is almost rudderless. You know, he didn't use those words, but technically that's what we're saying. So the ADC is coming to the rescue. So thank you once again. See you all next week, Friday. Bye.